Chapter 9 was about the law of contracts and sales. They defined a contract as a legally enforceable exchange of promises or an exchange of a promise for an act. Then they talked about contract law, which is grounded in the case law of the state and federal courts, as well as state and federal statutory law. Mentioned case law. Again, the law of contracts originated in judicial decisions in England and the United States. Later, states and the federal courts modified their case law through the use of statutory law. Uniform Commercial Code, to obtain uniformity among state laws, particularly law as applicable to sales contracts. The National Conference of Commissioners on Uniform State Laws and the American Law Institute drafted a set of commercial laws applicable to all states. Express contract, an exchange of oral or written promises between parties which are enforceable in a court of law. Implied contract, a contract that is established by the conduct of a party rather than by the party's written or spoken words. Unilateral contract, an exchange of a promise for an act. Bilateral contract, the exchange of one promise for another promise. A void contract, that is a contract that at its formation has an illegal object or serious defects. Voidable contract, a contract that gives one of the parties the option of withdrawing. A valid contract, a contract that meets all the legal requirements for a fully enforceable contract. Executed contract, a contract of which all the terms have been performed. Quasi-contract, a court-imposed agreement to prevent the unjust enrichment of one party when the parties had not really agreed to an enforceable contract. A valid contract, in order for it to be a valid contract, they said it has to have 6 elements: a legal offer, legal acceptance, consideration, genuine asset, competent parties, and a legal object. Actually, I wrote genuine assent. When these 6 elements are present, a legally enforceable contract usually exists. Talked about the definition of a legal offer. It's an offer that shows an objective intent to enter into the contract, is definite, and is communicated to the offeree. For a legal offer to be valid, you have to have 3 things. It must show objective intent to enter into the contract. Offer must be definite, must be some reference to subject matter, quantity of items offered, and the price of items. And the third is offer must be communicated to the party or the offeree intended by the offerer. Methods of termination of an offer. There are 5 methods of termination of an offer. Lapse of time. It said failure to respond within a reasonable period of time. Death of either party. And then it went on to talk about death of an agent or corporation, but in most cases the company continues on, so it's rare that that occurs. Destruction of the subject matter. If the item contracted for cannot be replaced because of an accident or an occurrence that is not the fault of the offerer, the offer may be terminated. Rejection by the offeree is the offeree. If the offeree doesn't accept the offer, it is terminated. And then the 5th is revocation by the offerer. If the offerer withdraws the offer before the offeree accepts it, the offer is terminated. So you would need to look into those in order to terminate an offer. Legal acceptance, an acceptance that shows objective intent to enter into the contract that is communicated by proper means to the offerer and that mirrors the term of the offer. That involves 3 requirements to be met for an acceptance to be valid. The first one is an intent to accept must be shown by the offeree. The intent must be communicated by proper means. The intent must satisfy or mirror the terms of the offer. The intent to accept means that it must be objective intent. The words, the conduct, and the writing are the examples that they stated for intent to accept. Communication of that acceptance. Any reasonable means of communication may be used in accepting an offer, and acceptances are generally binding upon the offer or when dispatched. Consideration, a bargain for exchange of premises in which illegal detriment is suffered by the promisee. A genuine assent to a contract that is free of fraud, duress, undue influence, and mutual mistake. Fraud, misrepresentation of a material fact made with intent to deceive the other party to a contract who reasonably relied on the misrepresentation and was injured as a result. Duress, any wrongful act or threat that prevents a party from exercising free will when executing a contract. Undue influence, mental coercion exerted by one party over the other party to the contract. Mistake, error as to material fact. A bilateral mistake is one made by both parties. A unilateral mistake is one made only by one party to the contract. Competency is defined as a person's ability to understand the nature of the transaction and the consequences of entering into it at the time that the contract was entered into. They touched upon insanity. If a person is adjudicated, I think it's supposed to be adjudicated, by a court of law to be insane, or is de facto or in fact insane at the time of entering into a contract, the individual will be allowed to disaffirm a contract. The court-appointed guardians may also disaffirm such agreements. Intoxication. A person who is intoxicated to the degree that understanding the nature of the contract and its consequences is impossible. Courts will look at it closely at the degree of the intoxication and decide whether or not the agreement should continue forward or if they should let them out of said agreements. Legal object, contract subject matter that is lawful under statutory and case law. Contracts that must be in writing. They were very specific. They said if it had interest in land or paid debts of another, then that contract must be in writing. Must be in writing if it specifies that it will last longer than 1 year. And they also made note that you should make sure that you set the date on that. Non-business contracts must be in writing to be enforceable. They're contracts in consideration of marriage and contracts of an executor or administrator to answer for the debts of a deceased person. They talked about creditors, beneficiaries of contracts, a contract in which the promisee obtains a promise from the promisor to fulfill a legal obligation of the promise to a third party. Assignment, the present transfer of an existing right. Assignment of contract rights. Certain class of assignments are not recognized by law. Assignments that materially change the duty of the obligor. Assignments forbidden by state statute. Any assignment forbidden by the original contract between the obligor, promisor, and the obligee, promisee. Contracts for personal services. Example that they gave was an artist contract to paint an individual's portrait. So that was Chapter 9. Chapter 10 talked more about the laws of the contracts and sales. They defined complete performance as completion of all the terms of the contract. Substantial performance is when completion of nearly all the terms of the contract, plus an honest effort to complete the rest of the terms, coupled with no willful departure from any of the terms. Breach of contract, failure of one of the parties to perform their obligations under the contract at the time their performance is due. Condition precedent, a particular event that must take place to give rise to a duty of performance of a contract. Impossibility of performance. They said that was a situation in which the party cannot legally or physically perform the contract. Monetary damages, dollar sums awarded for a branch of contract or legal remedies. Talked about punitive damages, monetary damages awarded in excess of compensatory damages for the sole purpose of deferring similar conduct in the future. Nominal damages are monetary damages of a very small amount. They gave the example of $1 awarded to a party that is injured by a breach of contract but cannot show real damages. Liquidated damages, monetary damages for non-performance that are stipulated in a clause of the contract. Equitable remedies, non-monetary damages awarded for breach of contract when monetary damages would be inadequate or impracticable. Rescission, cancellation of a contract. Reformation, correction of terms in an agreement so that they reflect the true understanding of the parties. And then they ended talking about the UCITA. It said it was a means of regulating the increasing volume of e-commerce and electronic contracts, which one of our homework questions is geared towards that. So I'll be talking more about that through my homework. As far as how that information affects me business-wise, anything that I have experienced, I recognize some of the language, like the damages and talking about whether they're punitive damages or not. Beneficiary, I think it touched upon, like if you're a beneficiary for somebody, taking on legal contracts. I know, like I think of when my grandmother passed away, my dad was considered the beneficiary, and some people didn't understand the true meaning of that. They just thought, oh, she left him everything. Well, she actually gave him all the responsibility of taking care of everything. So he had a financial obligation that he had to fulfill as that person. When my father passed away last year, he did not have a living will. So the law said that everything just automatically went to my mom and stayed with my mom, and any debts that he had, she would continue to be responsible for, and any items or materials that he has or any land would remain with her, and it wouldn't be split up between the children. So that's those are things that I'm familiar with as far as looking at the different things that Chapter 9 and Chapter 10 touched upon. And we'll discuss that further in the homework. Thank you.